Tenth Circuit rules, ADA failure to accommodate claims must prove adverse employment action. This month the Federal Tenth Circuit held in EXBY Stolley v. Board of County Commissioners, Weld County, Colorado that a failure to accommodate claim under the ADA must prove an adverse employment action. Federal circuits the majority came down in favor of the employer, extending defensive opportunities to this form of disability discrimination claim. The facts in EXBY Stolley v. Board of County Commissioners, Weld County, Colorado. Ms. EXBY Stolley was a health inspector for Weld County, Colorado. She suffered a broken arm which made it difficult for her to perform her normal job duties. The parties disagree over the facts that follow. The plaintiff alleged this set of events. She received a poor evaluation for being behind in work. After disclosing her physical condition, she met with her supervisors and human resources. The parties agreed to transition her to part-time office work. The pay difference in work hours was made up by workers' compensation. After this first meeting, her supervisor's manager asked plaintiff why she did not take disability and expressed anger that she would not. Eventually plaintiff grew dissatisfied with the part-time position and requested a second meeting. At this meeting all of plaintiff's proposed accommodations were rejected. At the end of the meeting her supervisor's manager talked to her and plaintiff understood the conversation to mean she needed to resign. Plaintiff met with human resources and looked at other job opportunities and long-term disability. Weld County, Colorado alleged similar events with some key differences. The employer alleged at the second meeting plaintiff requested a job should be created for her out of the job duties she could do and that she could not perform all of the normal job duties of her position. Nobody recalled discussing resignation. Instead, no final decision had been made and the defendant expected to continue the interactive process to accommodate her disability. At the conclusion of a 5-day trial the jury sided with the employer. Plaintiff appealed that the trial court improperly instructed the jury that she had to prove she suffered an adverse employment action. Adverse employment actions and failure to accommodate under the ADA. The appellate court wrestled with whether a failure to accommodate claim under the ADA requires the plaintiff to prove she suffered an adverse employment action. Under the Americans with Disabilities Act, an employer has a duty to provide a reasonable accommodation to a qualified individual with a disability. Failure to provide a reasonable accommodation violates the statute and creates a claim for disability discrimination. Federal circuits disagree whether the failure to accommodate is itself a discriminatory act, or whether an adverse employment action must follow the failure to accommodate. An adverse employment action in employment discrimination law is a serious and material change in the terms, conditions, or privileges of employment. The meaning of this term is well analyzed in employment discrimination law. Whether an employer's act qualifies as an adverse employment action is fact-specific and may be a disputed issue in the course of litigation. The majority opinion holds an adverse employment action must follow the failure to accommodate. The majority rests its position primarily upon analogizing failure to accommodate claims to disparate treatment claims under the ADA and other federal employment discrimination statutes. The majority fills in the ADA statutory language with analogies to Title VII and case law to assert the statute requires proof of an adverse employment action. It indicates the McDonnell-Douglas framework must be modified to omit the requirement that the employee show he or she was treated less favorably than a non-disabled employee, because the failure to accommodate is a discriminatory act under the statute. The majority fails to draw a compelling case why a failure to accommodate claim is sufficiently indistinguishable from a disparate treatment claim, or why a failure to accommodate is not itself an adverse employment action. Where Colorado employees go from here. Until the 10th Circuit or Supreme Court revisits this opinion, employees in the 10th Circuit are stuck following the majority's position here. It's unknown whether the plaintiff will request a rehearing en banc to let the entire court hear the case or ask the Supreme Court to weigh in. The apparent circuit split on this issue will almost certainly be addressed by the Supreme Court at some point soon, but that may be years away. The biggest problem with the majority's position is that it forces disabled employees who are denied reasonable accommodations to endure the absence of an accommodation until the problem compounds into something a court might agree is an adverse employment action. In between the failure to accommodate and the adverse employment action, disabled employees are likely to fall behind at work and generate a less favorable reputation for his or her work that will not be cured simply by remedying an adverse employment action. The long-term implications go far beyond the immediate adverse employment action. The mere refusal to provide a reasonable accommodation in many cases results in a less favorable employment situation than the disabled employee's able colleagues. That is the type of discriminatory impact laws like the ADA were enacted to combat. From a litigation standpoint, the majority's position makes cases more difficult for employees. Requiring the employee to prove an adverse employment action gives employers two additional defensive opportunities. First, employers obtain the opportunity to assert the alleged adverse act fails to meet the legal threshold to qualify as an adverse employment action. This helps employers in close cases where the adverse act is less obvious, like a termination. Second, it gives employers the opportunity to allege the adverse employment action occurred due to a non-discriminatory reason. That puts employees in the strained position to argue the employee underperforms, and every possible reason for underperformance relates to the unaccommodated disability. Pursuing failure to accommodate claims with Denver employment lawyers. The decision in EXBY Stolley will make pursuing failure to accommodate claims under the ADA more difficult and more necessary to hire a Denver employment lawyer to represent you. Employees with failure to accommodate claims will have to look closely at what adverse employment action occurred and properly allege it in the lawsuit. Plaintiffs may allege under the ADA that the failure to accommodate deprived the employee of enjoyment of the benefits of employment as an adverse employment action, but it is not yet clear how the 10th Circuit will treat those arguments. Each of these claims must be carefully reviewed and alleged from the administrative charge through filing a lawsuit. Experienced employment lawyers in Denver, Colorado can make it an even battle on your behalf. If you believe your employer failed to reasonably accommodate a disability, then you should talk to a Denver employment lawyer right away.